A senior advocate of Nigeria, Mr. J.B. Daudu, has urged the National Assembly not to alter the existing burden of proof in election cases in the proposed amendments to the Electoral Act. He argued that requiring INEC to prove the validity of elections would make it appear aligned with the winners it declared, thereby damaging its credibility. He said Section 60 of the Electoral Act regulates how votes are counted, recorded and transmitted, ensuring results are publicly declared and electronically backed up.
The National Assembly, through the Senate, has publicly declared as part of the proposed electoral reforms that it will cause INEC to assume the burden of proof. And they are to prove that the election in issue was validly conducted. So imagine the scenario. When you petitioner says an election was not validly conducted, you leave the person who opens the case will be INEC to come and prove that it was validly conducted. I do not know what the senators were thinking of at that material time, but I'm sure lawyers will be very startled at the thought of this. And I'll tell you the intention. Now, so many commentators have applauded the proposition as a bold move. Their position, as enunciated by the Senate President, Godswill Akpabio, GCON, and his position is premised on the platform. This is the sole reason why he gave, that INEC is the custodian of electoral documents, and they have been disruptive, to use his words, of the electoral process by not releasing such documents to petitioners timeously. Other reasons for such a proposal are provided in the Senate President's interview with the media after the session. There are several reasons why the status quo of the burden of proof in election cases cannot and should not be tampered with or distorted. It must remain with the petitioner. Such a measure will damage permanently the avowed neutrality of INEC. One of the fundamental rules of INEC is to act as an impartial umpire in the electoral process, including in post-election dispute resolution. The notion of neutrality means that INEC must discharge its duties without favor or bias towards any candidate or party. It must not act or support a contestant in the election, or even after the election, an election it has supervised. And it must maintain not only the perception, but the reality of fairness, especially after the elections. For example, in its code of conduct, INEC states that the election officials shall, in quote, not show to or do anything that demonstrates a bias or preference for any political party or candidate, and shall maintain an atmosphere of fairness, neutrality, and decorum throughout the electoral process. Once INEC is made to discharge the burden of proof of whether an election is marred by corrupt practices, or there is non-compliance with the Electoral Act, or that the respondent did not win the election by majority of lawful votes, it means that INEC has aligned itself with the respondent, who was declared as elected to prove or validate his due election return. Now, this is what I think the politicians want to achieve. They are the respondents. The presumption is on them, is that the election was properly conducted. They then get INEC to come and produce documents that they should have subpoenaed INEC to bring. They don't want to pay the cost. They will not fund INEC to do that. But what they forget is that before you catch a monkey has seen you. If they make the mistake, all INEC needs to do is to come and keep quiet, and that means the election is null and void. So the risk is heavier on their own side. INEC does not have the manpower to defend the case for every House of Assembly seat, House of Rep seat, Senate, and leave their own work. Indeed, they come to tribunal and say, our hands are up. We are neutral. We are not doing anything. You people kill yourself. Prove your case. But now the politicians want them to now come and establish the validity of their elections. They will be in for surprises. Who is responsible for the low level of electoral maturity in Nigeria? Is it electoral umpire INEC? Or is it the law courts that adjudicate over electoral disputes? Or is it the class of persons known as politicians who present themselves from time to time for election into political offices? The answer can best be discerned from further posers thus. Who out of the listed groups engage in vote buying, employ thugs and other violent persons to disrupt election, manipulate the electoral system in all the ways frowned against by law? Who? We all know the answer, and until our politicians find the courage and candor to participate in free and fair elections, we will continue to be victims of manipulation and buck passing.